My mouth too long then. All right, I apologize. Thank you.
Thank you, counsel. All right, the next case is STRUVE versus DOERFLEIN.
May it please the Court, my name is Leslie Davis. I'm here on behalf of Appellant Linda Struve. I would like to reserve 5 minutes for rebuttal. This is an appeal from a final judgment of injunction for protection against domestic violence rendered by the 5th Judicial Circuit Court on March 15, 2011. It involves a dysfunctional relationship between the parties, a daughter and her mother, that became very strained when the daughter took her terminally ill father away from his residence with the mother in Brevard County to Ocala, where the daughter resided. Evidentiary issues that occurred during the injunction hearing precluded the entry of a domestic violence injunction in this case. Additionally, the situation in this case involving a terminally ill family member did not warrant an injunction. It was really a situation that exacerbated an already dysfunctional relationship. Once the father passed away, that exacerbation ceased to exist.
Let me ask you this. Of the 5 points that you have raised in your brief,
Yes.
which of those 5 were raised to the trial judge specifically, if any?
The fifth argument that the situation did not warrant a domestic violence injunction because of the terminally ill father, that this just wasn't a situation that was conducive to the issuance of domestic violence injunction, was specifically raised below.
So how are the other 4 preserved?
Well, first of all, with respect to the recording of the purported telephone message, there's nothing in the case law that I have found that requires a contemporaneous objection in that situation.
Now, the record that was typed up said portions of it were unintelligible.
Yes.
Did the trial court indicate that it couldn't understand it, or is this just that potentially the court reporter couldn't understand it?
Well, there's nothing in the transcript that indicates that the judge couldn't understand it, but there are sections that say unintelligible where the judge is speaking. So it doesn't look like the judge said anything about the recording not being...
If the trial judge could understand it completely, and that was the basis of his ruling, and your argument is the court reporter couldn't take it down, it was unintelligible, is the remedy to get a new trial, or is the remedy to reconstruct the record and get the trial judge the same way you would if a court reporter weren't there? If there had been no court reporter there, in order to appeal, you would have had to go to the trial judge and say, let's reconstruct what happened.
Right.
You have to do that in this context if the trial court could understand the recording just fine?
The problem is that the trial judge didn't understand what the recording said. The trial judge basically determined that recording, the voice on the recording said that she was going to eliminate someone from the earth. The original, the Fifth Circuit's recording was sent to this court, so it is here. I don't know if you've all had an opportunity to listen to it.
And if we listen to it and we can interpret it, and we can fully understand it, does your argument that the tape is unintelligible and therefore that's a basis for a reversal go away?
Well, if you could listen to it one time, played at full speed, and understand it, then I would agree that my argument that it was unintelligible goes away. I do not believe that anyone can listen to that recording one time without playing it multiple times and going back through and listening to it, perhaps slowing it down and really understand what it's saying. I do not, I have a hard time believing that the judge could hear it and understand all of the words, particularly since the judge, she basically took the position, she parroted the testimony of Ms. DOERFLEIN, the daughter, in saying, I heard that someone was going to be eliminated from the earth. In our office, we listened to it multiple times with quite a few people, never heard that language, and did provide what we heard from the recording in our amended opening brief.
How were arguments 2, 3, and 4 preserved for appellate review?
I would argue that that they're fundamental error, because particularly as they pertain to the recording and the best evidence rule, the hearsay.
Do you have any case which says a best evidence rule violation is fundamental error?
I could not find one, Your Honor, but I didn't find anything that said it wasn't. And particularly with the best evidence rule, it seems that it's the court's gatekeeping function. You know, the court does have some duty, arguably, to determine whether or not the evidence coming in is appropriate, is, you know,
Even if the lawyer doesn't object to it coming in, even if the lawyer doesn't raise any question about it, the judge has some independent duty to evaluate each piece of evidence that's offered to determine whether or not there is some evidentiary standard which should keep it out?
Well, at the very least, I believe this court has a duty to look at the evidence that came in and determine whether or not, without that evidence, the merits of the case should have gone the other way, whether that was a fundamental error that need not have been preserved, in one of those narrow exceptions to the contemporaneous
What's the standard for what qualifies as fundamental error in a civil lawsuit?
The error is fundamental if it goes to the very foundation of the lawsuit, in this case the petition. If it goes to the merits of the petition, there's a case, Sanford versus Rubin, 237 Southern 2nd, 134 from the Florida Supreme Court in 1970, that gives that definition. So if it's not just collateral, if it's not something that's not really going to the core of what the court is deciding, then it's not fundamental. And of course, there's some gray area there. But in this case, there's no question but that the recording was fundamental to the court's decision. The judge said, this is a major event that was disturbing because there's a statement that was made that she's going to eliminate her from the earth. That's a threat. Was
it hearsay? Was it admitted to prove the truth of that statement, or was it admitted just to prove that the statement was made?
I believe it had to have been hearsay because it was made to prove the assertion, the threat, the fact that a threat was made.
But that doesn't go to the truth of the statement that was made, correct?
Well,
if the evidence is she said I should be eliminated from the earth, we're not looking at whether the truth of whether or not she should be eliminated from the earth.
That's correct.
We're only looking at whether the statement was made, correct?
The statement was made, whether
so the tape was introduced to show that the statement was made, not whether the statement was true, correct?
Correct.
Doesn't that take it out of the definition of hearsay?
That may take it out of the definition of hearsay, but it doesn't take it out of the best evidence rule.
Well, you have another ground saying it was based on impermissible hearsay. Wasn't that correct. The hearsay? Wasn't that the evidence you were basing that on?
That's part of the hearsay, as well as some of the testimony from Ms. DOERFLEIN as far as, what she remembered from some of the messages that she'd received, etc. The one piece of evidence that I believe was clearly not hearsay was the daughter, Ms. DOERFLEIN's, description of the hospital incident and the poking that went on. But everything else was, this is what she said, this is what I heard. So I do believe there are hearsay issues with respect to the testimony and the recording that was played. I think the bigger issue is the fact that the recording is unintelligible. This court then does not have an official record. There's no transcript before this court with any language about anyone being eliminated from the earth, which is what the judge primarily relied on in making the determination that a domestic violence injunction was warranted in this case. I think that's a fundamental problem for this court. I think it's a fundamental problem for my client. This court can't review what that judge purportedly heard and make a determination as whether or not that evidence supports the judge's determination.
Well, if that's the case, don't you lose because the burden is on you to show that the trial court made an error? Well, just as if there had been no court reporter there and you had not reconstructed the record, you would lose, right?
Well,
because you can't meet your burden of showing that the trial court
Yes, we can, because we submitted the original recording to this court. with the record. So not only do we have an amended transcript where the court reporter made an attempt to provide more of a transcript with respect to that recording, we also submitted the original recording from the Fifth Circuit, which this court can listen to and make a determination. Beyond that, I mean, and we've also recreated ourselves, after listening to that portion of the recording a number of times, what it says. So I believe we've met our burden in that instance. With respect to the argument that the evidence was not sufficient to support an injunction for domestic violence in any event, aside from the evidentiary issues, courts must consider the alleged abuser's behavior within the context of the relationship and the relationship's history in ascertaining whether and to what extent the alleged abuser poses a threat to the petitioner's safety. Here, as mentioned, there was a dysfunctional family to begin with. The daughter testified that she hadn't lived with a mother since she was 18. She was 47 at the time of the hearing. The father had a terminal illness. He was very, very ill. He lived in Brevard. She physically took the father away from the mother, took him to live with her. The distance is 150 miles. Obviously, that was traumatic for the mother. There was a situation where there was a lot of apparent stress in the mother-daughter relationship to begin with. All of the complaints that the daughter allegedly had were related to that removal of the father, the terminally ill, very, very sick father, from his marital residence and taking him to Ocala to reside. Issues with the mother and trying to visit the husband, going to the hospital, some issues with respect to things said to the mother being upset. All of it pertained to this ill family member. Once he passed away, Mrs. Struve visited the home only one time, right after he died, to collect his things. And until about 3 or 4 days before he passed away, she had been the personal representative of his estate. Apparently, the daughter and the son had some participation in his will being changed and someone else being executor or personal representative. But Mrs. Struve came to the home to collect his truck, to collect some personal belongings. Police were called. There was a trespass complaint made. So I think on both sides here, the level of stress, the level of anxiety situationally went up dramatically. Once he passed away, once Mrs. Struve collected his things, it was over. The situation no longer existed, and there was really no need for any kind of injunction, particularly one where the court has made it, indefinite.
Was that argument made to the trial judge?
Yes, that argument was made in the hearing below, and I believe it's one of the strongest arguments. Families go through crises on a regular basis. It's unfortunate. It's unhealthy. But in terms of the collateral consequences of someone being subject to a domestic violence injunction, when it's really a situation that's temporary, that's exasperated an underlying situation, but that passes, I do not believe that the domestic violence injunction statute was, enacted to address this sort of situation. Maybe temporarily, maybe while the situation's going on, but once that situation has abated, there's no need for an injunction. And in this case, the injunction was entered after the husband passed away. Once the situation had resolved, the mother returned to Brevard County, the daughter's in Ocala. Really, definitionally, hard to say that the daughter has a reasonable fear of imminent harm in that situation, and to the extent that she testified that there were any incidents of domestic violence, they were situational, they were sporadic at the most, and there are a number of cases that talk about that not rising to the level of warranting a domestic violence injunction. I'll reserve the rest of my time for rebuttal if there are no questions.
We've got about 6 minutes left.
Thank you.
May it please the Court, my name is Stacey Yeomans. I represent the appellee, Ms. Linda DOERFLEIN. I'd like to begin with the statement the judge made as she rendered her determination, and she said, based on everything I've heard, particularly the hospital incident, the injunction is warranted. So the position of the appellee is that there was a wealth of other information that was placed before the judge in this particular matter. The appellant's version of events would make it seem as if we played a recording and then rested, and then the judge ruled. In fact, the judge took testimony from Ms. DOERFLEIN, the appellee, and got a history as to her relationship with her mother. It certainly was dysfunctional, no doubt about that. It certainly worsened upon the rapidly deteriorating health of her father and Ms. STRUVE's husband. I take exception with the portrayal of events being that the appellee went down and collected her father. Her father actually chose to reside with the appellee, Ms. DOERFLEIN, and that was put before the judge as well. In this matter, under Florida Statute 741.30, a person is eligible for the issuance of a domestic violence injunction if they meet two criteria. They can either be a victim of domestic violence, or there has to be a reasonable cause to believe that he or she is in imminent danger of becoming the victim of any act of domestic violence. So what the judge heard on this occasion was a history of threats that were made on a routine basis towards Ms. DOERFLEIN on her phone at a home in which a child also resided, and that the appellant knew was the case. Statements that included that the appellee, Ms. DOERFLEIN, would be sorry when she got home, just wait till you get home, something bad's going to happen to you and your family. And she told the judge that that kind of stuff happened all the time, that the phone calls were voluminous, harassing, and threatening. And the judge inquired, was this the case 6 months prior to your petition you sought for an injunction for protection? And she said, yes, ma'am. In fact, the portrayal of the relationship gave the appearance that matters were escalating, that her mother had left her a message, I'm not taking this anymore. And then it led up to an incident in January, which ultimately resulted in the petition being sought, an incident that occurred at the hospital while Mr. Struve was dying. He was in his hospital room, and the appellant, Ms. Struve, to use the language of Ms. DOERFLEIN, came bursting into the hospital room. And she goes directly up to Ms. DOERFLEIN, the appellee, and she starts poking her in the chest. And at that time, Ms. DOERFLEIN exemplified to the judge just how that took place. And she said she was screaming in my face, poking me in the chest, that she was crying, that Mr. Struve was crying, and ultimately security had to escort Ms. Struve off the property. So at that point, the appellee did seek the injunction for protection. The injunction set out initially all the threats that the judge ultimately heard about, to include the threat that the appellant was going to go to the ammo store and get ready for her and her brother Kenny. And she explained to the judge Kenny was her brother, and that Ms. Struve liked to use her word, brag about having a concealed weapons permit, and that for her to say she was going to the ammo store to get ready for her, she interpreted that as a threat that she would use her firearm. So the judge also heard that. When the judge made the ruling, she had before her evidence that Ms. DOERFLEIN was a victim of domestic violence, as well as the second prong, which is Ms. DOERFLEIN qualifying as a person with reasonable cause to believe that she was in imminent danger of becoming the victim of any act of domestic violence, which falls squarely under Florida Statute 741.30. Now, when you look at the appellant's brief, the appellant concedes that the applicable crimes, potentially applicable crimes, would be stalking, battery, and assault. If the appellee, Ms. DOERFLEIN, met any of those as the victim of any of those offenses, then the judge was right to issue the injunction. When you look at the facts that were before the judge, you have an instance where she described a history right up until 6 months prior to the petition being sought of harassing, threatening phone calls in which, as I've visited before, the appellant said she was tired of this, that she was going to the ammo store to get ready for her, that they would be sorry when they got home, statements like that. Then, on top of that, she comes to the hospital room, and there's a violent confrontation that takes place in a hospital room in front of the dying Mr. Struve. Anytime there is a pattern, a course of conduct that is meant to harass a person, that falls within the language of 784.048, which is stalking. And whenever Ms. Struve engaged in this continuing pattern of conduct, coupled with threats, with confrontations that even after the petition was sought occurred at the home of Ms. DOERFLEIN, where she went to her home. And the police ultimately had to be involved there and issue a trespass warning. You've got an individual who is being escorted off hospital property. You've got an individual who's being issued trespass warnings, and it's escalating. And when you have a continuing course of conduct, it falls within the language of 784.048, which falls within the language of 741.30, and would make the appellant in this case a victim of domestic violence. Also, under the same theory, an assault was committed on Ms. DOERFLEIN in that there was a fear, and that fear was coupled with an apparent ability to carry out the threat. She threatened to do harm to Ms. DOERFLEIN, and she coupled that with traveling all of that distance to confront her, whether it was at the hospital or at her house. There was a confrontation that took place. And by charging someone and starting to jab them in the chest, you're showing an apparent ability to carry out the threat you've made. So under 741.30, under that basis, she also qualifies as a victim of domestic violence. Finally, there is the offense of battery. I believe in the appellant's brief that is discounted because there was no intention of harm. Under Florida law, there does not have to be an intent to do harm to commit the offense of battery. Battery is an intentional touching without consent. And it can be as simple as spitting on another person. In this case, you have a very volatile situation in a hospital room where she comes bursting into the room and starts jabbing her finger in the chest of Ms. DOERFLEIN, and ultimately was escorted off the property by the hospital staff. So in that instance, she also qualifies under 741.30 as a victim of domestic violence. And the judge heard all these things. And under that prong alone, the domestic violence injunction was issued properly. Now there is also an alternative to that, and that is whether Ms. DOERFLEIN had a reasonable cause to believe that she was in imminent danger of becoming the victim of any act of domestic violence. And on that point, the court heard again about the threats that were made, about the confrontation at the hospital. You have a moment where a recording was played before the court. And that recording, the judge was in the best position to hear it, and she did. And she didn't just hear it and we moved on. She heard it and inquired about it. And she asked Ms. DOERFLEIN, "Is that your mother's voice?" And Ms. DOERFLEIN said, "Yes, it is." And she asked about the threats that happened during that time frame. "Did you know your mother had a firearm?" "Yes, I did." And they discussed the fact that she had a firearm and the fact that she had threatened to go to the ammo store to, quote, get ready for her and Kenny. So there were circumstances surrounding the phone message that were put before the court. Now, Your Honor pointed out a very well-made point that the judge was interested in whether she made this statement. And she gave Ms. Struve an opportunity. She asked Ms. Struve, "Is that you on the recording?" And Ms. Struve had an opportunity to, if you follow the appellant's theory, explain this as some innocuous statement by a third party, not her, but she didn't do that. Instead, she denied it was her voice at all. She said, "It's not me, that's not my voice." And the court, in its ultimate determination, found that based on her determination as to credibility, she believed Ms. DOERFLEIN, that was Ms. Struve's voice on the message, and that the message, she did perceive the message to be threatening in nature. So she had much more information than just a single recording to rely on, although it was an aspect that was covered in the hearing. And if you look at the entire matter, the entire record, if the totality of the circumstances are such that the ultimate decision was right, even if the court perceived some improper admission of evidence, if ultimately the final result is right, and we have case law to that extent, then no decision should be reversed on what amounts to harmless error. Although we're not conceding that the admission of the recording was harmless error. In fact, there was no objection as to the recording at all. So our point would be that that particular issue was waived. So in sum, when you look at the entire record, which is what we would request the courts, Your Honors, to do, there was evidence that she was a victim of domestic violence. There was evidence that she had an objectively reasonable fear of imminent violence, and as such, it was properly issued under the statute 741.30 of the Florida statutes, and the court was proper in doing so, in issuing the injunction. If the court has no further questions, or has any questions, I think I'll wrap it up. Thank you very much for your time.
Very good. Thank you, counsel.
I'd like to reiterate that everything that transpired between the mother and the daughter transpired after the father was removed from his long-term marital residence and taken to Ocala. So again, we're talking about a finite amount of time where the underlying poor relationship reached a critical point. With respect to the judge and the totality of the evidence argument, I point out that the judge stated the real critical issue is who's on the tape, because there's no question that the court did hear the words, "eliminate someone from the earth." Again, we listened to that actual tape a number of times. We did not hear those words. It's reflected in the amended initial brief. With respect to the argument that, well, there were all these other things that the court relied on, the transcript doesn't bear that out. The transcript says, with a combination of everything I've heard, particularly with the incident at the hospital, which tells us what we know, unintelligible. On that issue, as far as the domestic violence, that's unintelligible. And the testimony regarding her telephone contact, I believe from a credibility standpoint, that there was just unintelligible. That her daughter, who's an adult, to say and is known, has heard her mother for all of her life testify that that was her mother's voice. I do not see how on this record the court can say that the underlying trial judge relied on the totality of the evidence or on the hospital incident to determine that domestic violence had occurred. As far as the trespass warnings, I don't see in the transcript any reflection that there was ever a TRO or any type of order entered precluding Mrs. Struve from visiting or trying to visit her husband. They had been married for a long time, to see him while he was dying, basically. She did come to the house one time, and again after he died, to collect his things. That the daughter actually was the one who called the police, and again, I think she was within her rights to go over there to visit and or to go collect the things that actually belonged to her. With respect to battery and the poking incident, our brief does say that the definition of battery is the intent to cause a harmful or offensive contact, not just harm. According to Ms. DOERFLEIN, her mom traditionally poked. That's just her behavior. So our argument was that it's a habit. It's not that she's necessarily trying to offend. But in any event, an isolated poking incident would not support a domestic violence injunction under Gill v. Gill, which is 50 Southern 3rd 772 from the 2nd District Court of Appeal. The court said that the former wife did not establish that she was a victim of domestic violence based upon the former husband having pushed her the year before. It was one incident. The court said that's just not enough to support the entry of a domestic violence injunction. With respect to the calls and allegedly something bad going to happen, there's a little more in the transcript about that in terms of Mrs. Struve suggesting that perhaps God is going to do something. Not that she's going to do something, but that some of the behavior going on with the daughter from her perspective might end up offending a higher power. So there's a little more context to those comments than has been provided by counsel. Unless there are any questions, that's all I have.
Thank you, counsel.
Thank you.